off of that top list.
Hudson and Goodwin have been gone.
And Winston. I know we just did
Goodwin
Winston.
is gone.
Or Goodwin. Yeah, Goodwin.
And this is Winston.
Yeah.
This is Edward Winston.
Okay, but I'm just asking, besides Hudson and Goodwin, who else have you done?
That's it.
That's it.
Oh, okay, dope. Ready.
Okay. All right, I got all my videos going. This calling case number 220-560-2001. People of the state of Michigan versus Edward Darwin Winston Jr. Counsel.
Alicia Taylor Coleman, 256-278 on behalf of Mr. Winston Jr. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived. As to bond.
Your Honor, as to bond, we are requesting a reasonable nominal bond on behalf of Mr. Winston, possibly with tether. Mr. Winston is 62 years of age, will not have any contact with the complainant, but has a long history of the complainant assaulting, very violent towards him. Defendant is afraid of complainant, does not want to have any contact with him. He is not a threat to the general community. We understand the seriousness of the allegations, but I, again, cannot reiterate enough that there is a very long history of the complainant attacking, assaulting, being very violent towards Mr. Winston. And he looks forward to his day in court to bring out that information. He is on disability. He is a high school, 1976 high school graduate of McKenzie High School. He's on pain medications, high blood pressure. He had a motorcycle accident several years ago. I do not have, and I think that's significant for the court to pay attention to, any priors. Mr. Winston has made it to 62 years of life. And except for being very afraid and a victim to the complainant, no priors that I have. We are asking for the court a nominal bond or a personal bond with tether for Mr. Winston, who is on disability.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties. One, Mr. Winston. The court would note that the underlying charges are serious and assaultive in nature, assaultive on their face for most of them. The court will further note it does not have a prior case history. There's no indication he's a flight risk. Court does not have a prior criminal history. No indication that he's a general danger to the community. However, this court does have some concern with the general safety of the complaining witness and victim, in this particular case of Ryan Wiley or Willie. Sir, you are to have no contact with Ryan, Edgar, Wiley, or Willie. Do you understand that, sir?
Yes, as long as he's evicted out of my house.
Mr. Winston, no talking, no talking. You just say yes or no when the judge asks you if you understand, okay?
Yes.
Let me be as specific as possible. Nothing verbally, nothing in writing, nothing in face-to-face, not through social media, not even through a third party. No contact means no contact. Do you understand that, sir?
Yes, I do.
Even if you see Mr. Wiley at a public space or public park or a retail store, you are the one that has to leave that public space or park. You're the one that has to leave that retail store if he appears. Do you understand?
Yes, I do.
Even if Mr. Wiley reaches out to you in any form of communication, you are not to respond. If you respond, you may be the one that is found in violation of these bond conditions and can be arrested. Do you understand that, sir?
Yes, sir.
You are not to possess, purchase, use any firearm or weapons. Do you understand that, sir?
Yes, sir.
Now, the court has some concern, obviously, with the safety of Mr. Wiley, and is hoping that the no contact order would be enough. The court always has to weigh a person's freedom or incarceration and the general safety of the individual. Given in terms of these are allegations, but given that at this point in time, the alleged allegation that a weapon was used, that weapon was fired, and there was actual injury to the victim, the court takes that seriously. And the court does not believe this was random, that it was directed. So the general community at large may not be a concern, but definitely Mr. Wiley's concern. His safety is concerned, especially if this has been ongoing. So a GPS tether would be in place. A GPS tether. Didn't sound like, I didn't hear that your client is employed.
He's on disability.
You said he is disability, correct.
Yes,
so a GPS tether. I will allow him to go to his medical appointments. But other than that, he is on house arrest with the GPS tether. I will allow in this particular case, given that he's on disability and there sounds like an inability to pay, which is a far cry from what I normally would do, counsel and Mr. Winston, which there would be an attachment of some type of monetary bond, given the sheer seriousness of these charges. But given that it is directed and taking the argument that this is ongoing, the court is hoping that no contact and a GPS tether will keep Mr. Winston with a calmer and cooler head and remain away from Mr. Wiley. Even if he reaches out to you, sir, you're not to respond. Do you understand?
I understand.
Thank you. Court's going to enter a $25,000 personal bond, $25,000 personal bond. No money is needed to be released today on these charges. If Mr. Winston violates, he may not receive a personal bond in the new case against him, or the additional case against him. The next court date is the probable cause conference, March 7th at 8:30, March 7th at 8:30. Preliminary exam, March 14th at 8:45, March 14th at 8:45 is there, and that's in front of Judge Jones. Anything further, counsel?
Nothing further. Thank you, Your Honor.
Thank you. You're all set. Have a good day.
One. I'm one. Step on the line, saying.
State your name, sir.
Come on, Williams.
Good afternoon. Kamon Williams, case number 220-56018. People of the state of Michigan versus Kamon Vasco Williams. Counsel.
Good morning, Your Honor. Delisha Taylor Coleman, P56278. On behalf of Mr. Williams, he stands mute. Oh, it's afternoon. I'm sorry. Good afternoon, Your Honor. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond.
As to bond, Your Honor, with this being in the middle of a pandemic, Mr. Williams being 19 years of age and a lifelong resident of Michigan, no prior convictions, no capious history that I'm aware of, just recent high school graduate of Redford Academy, understanding that he cannot have any weapons in his possession as he comes back to court and deals with this matter. He does reside with family members and would reappear at all future court dates. We're asking for a personal bond.
Thank you, counsel. Court search representation of counsel as to the community, family, employment ties of one Mr. Williams. Court would note the underlying charge is non-assaultive on his face. Court further notes it does not have a prior capious history nor criminal history for Mr. Williams. No indication he's a flight risk or a general danger to the community. We're still in the pandemic, thus this court is inclined to give your client a chance, given his age. Sir, you're not to possess, purchase, use any firearm or weapons. Do you understand?
Yes.
Court's going to enter personal bond $3,000. Personal bond $3,000. Monies need to be released today on this charge. Next court date, probable cause conference, March 8th at 8:30. March 8th at 8:30. Preliminary exam, March 15th at 8:45. March 15th at 8:45. That's courtroom 440, don't have a specific judge. It's a
Thank you.
blind job, but courtroom 440. You're all set. Thank you, sir.
Thank you, Your Honor.
Thank you, counsel.
Just run. Huh? You wanna hang tight? Yeah. Step on the line, man.
Oh,
Oh, no, you're not. I need Bird. Where's Bird at? Derek.
Derek Bird.
Yeah.
I got him.
So on.
Come on, Bird. I'll take you back.
Good afternoon. State your name, sir.
Good afternoon.
State your name, sir.
Derek Bird.
Derek Nicholas Bird. All right. Calling case number 220-55866. People of the state of Michigan versus Derek Nicholas Bird, counsel.
Alicia Taylor Coleman, P56278 on behalf of Mr. Byrd. He stands mute, waives a formal reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived as to bond.
Esteban, these are non-assaultive on their face. While they do directly relate to Mr. Byrd's history, my understanding is that the last thing he had was in 2016. This is a matter from 2020, Your Honor. Only entered into the computer approximately, maybe 9 days ago in 22. Mr. Byrd has never been arraigned on these charges, was not even aware of these charges. He works at Forge Temporary Services, and he is a high school graduate. He lives with his mother and has 2 children and would reappear at all future court dates. We're requesting a personal bond.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties of one Mr. Byrd. The court would note that the underlying charges for him are non-assaultive on the face. Court further notes it does not have a prior capious history for Mr. Byrd. There's no indication that he is a flight risk. And again, this is Derek Nicholas Byrd. The court notes that it does have a prior criminal history. The 2016 case sometime has a lapse from that felony conviction. And this particular matter, this court will use as a factor, but it will not be the main factor. Sir, you are not to possess, purchase, use any weapons or firearms. Do you understand?
Yes, sir.
We're still in a pandemic, thus this court is inclined to enter a personal bond, $5,000, personal bond, $5,000. No money is needed to be released today. No indication he's a general danger to the community. Sir, your next court date is March 7th. Probable cause conference at 8:30, March 7th. Probable cause conference at 8:30. Preliminary exam, March 14th at 8:45. That's in front of Judge Archer. Anything further, counsel?
Nothing further. Thank you, Your Honor.
Well said, sir. Have a good day.
All right. Yep. What do you think, though?
Dwayne Bird.
Dwayne Bird, thank you. Dwayne Charles Bird, calling case number 220-55866, people of the state of Michigan versus Dwayne Charles Bird, counsel.
Alicia Taylor Coleman, P56278 on behalf of Mr. Byrd, Your Honor, and he stands mute, waives a formal reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived as to bond.
Esteban, we are requesting a personal bond. These are non-assaultive charges. Mr. Byrd understands he is not to have in his possession or use any controlled substances that are not prescribed to him. We do not have that he has any capious history. This matter is from 2020. Also, Your Honor, only being entered approximately 9 days into the system. He has never been arraigned, was never aware of these charges. He does have high blood pressure, residing with his brother, and has a 1-year-old son. He is currently looking for work, but he is a high school graduate from Henry Ford High School. We're requesting a personal bond.
Thank you, counsel. First, heard the representation of counsel as to the community, family, employment ties of one Mr. Dwayne Charles Bird. Court would note that the underlying charges are non-assaultive on their face. Court further notes it does not have a prior case history for Mr. Byrd. No indication he's a flight risk. Court does have a prior criminal history for Mr. Byrd, a 2015 felony conviction for fleeing from the police, second degree, out of the Third Circuit. We also have a companion reckless driving out of the Third Circuit. We also have a 2012 felonious assault out of the Third Circuit, 2006 attempted possession with intent to deliver out of the Third Circuit, and a 99 case attempted possession of controlled substance less than 25 grams out of the Third Circuit. One of those matters is assaultive. Some the court will know sometime has elapsed. That's a 2012 case, but assaultive nonetheless. It will be a factor, will not be the main factor, as well as the other criminal conviction. We are still in a pandemic. Sir, you're not to possess, use, purchase any narcotics or illegal substances. Do you understand?
Yes, sir.
Court's going to enter a $5,000 personal bond, $5,000 personal bond. No money needs to be released today on this matter. Next court date is probable cause conference March 7th at 8:30, March 7th at 8:30, preliminary exam March 14th at 8:45, March 14th at 8:45. There's no indication he is a flight risk. You're all set.
Thank you.
If you need to grab that chair, if you can lean on. Don't stand, just stand up there. Just hold on to it and stand so we can see. Oh, okay. I appreciate it. Make sure
State your name, sir.
Elijah Smith.
Elijah Smith. Okay, calling case number 2256017. People of the state of Michigan versus Elijah Dariel Smith. Counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Smith. He stands mute, waives his formal reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived as to bond.
As to bond, we are requesting a personal bond that Mr. Smith not drive without any valid license. He does not have any priors that we are aware of, nor any caseous history. He is 18 years of age, young, living with his mother and sister. He is employed with DoorDash and a recent high school graduate from Redford Academy. He recently fell down the stairs and has had very serious pain from that incident. He's never been in jail. The police came to his house. There was no resistance. He wasn't even aware of this warrant and would reappear at all future court dates. We are requesting personal bond.
Thank you, counsel. We also have Officer Schwab. Is this the case, Officer Schwab, you wanted to weigh in on?
Yes, Your Honor. In regards to bond, we request either a cash bond and or included GPS tether. Through our investigation, this is involving a critical hit and run accident where Mr. Smith fled the scene of this accident. We executed a search warrant for his home where we located him. He was placed into custody. Through a search of his phone, he posted on, this accident happened on the 16th of February. On his cell phone, he made conversations on 2/18 of 2022, approximately 8:08 and 56 seconds PM, states verbatim that no, they ain't. And this is going to be reading from what he texted, that I ain't done looked it up and they can't go through my phone. And if they do, I'm going to do the exact same thing I did that night. GTFO, which means get the F out. And that's the same. And that's the last place I'm going to is jail. I'm not even trying to be funny. I'm going to damn near leave Michigan, go live with some family out for a little bit if I find out there's a warrant out for my arrest. Our fear is that that he has a possibility of fleeing the state of Michigan to basically leave the state without being come up to basically finish up the charges on Mr. Smith.
Thank
If
you.
I can respond to that, Mr.
Detective.
Smith is 18 years of age and clearly, I'm gonna say young and dumb, but, and I think, based on what the officer wrote and, or stated, not to say, you know, I believe that it's a fact, all of this is allegations, but we would believe that a GPS tether would be sufficient. Mr. Smith does not have, he's not charged with fleeing and eluding. He's receiving and concealing, and then this accident causing serious impairment. There's no allegation that he was aware of the warrant and took off, only that he was making statements to someone at a time that, you know, again, 18, and you know that their minds are not fully developed. So we would ask for a GPS tether and house arrest, but a personal bond.
Thank you, counsel. Court such a representation of counsel as well as from Detective Schwab as it relates to Mr. Smith. Court would note that given the charges, they are serious, serious on their face. Court would note that it gives this, it has some concern, obviously, with the general safety of the community. A person was injured in an accident allegedly caused by Mr. Smith. Obviously, accidents do occur, but then the follow-up actions is what has this court concerned with, is obviously that allegation of the charge of not stopping. Court will also know the Mr. Smith's age as well. To counsel's point, being young and obviously not knowing how to be responsible in this particular situation. But there was a series of actions, alleged actions, that put him in front of this court today. And so the court must also take in the information from Detective Schwab and weigh that as well, whether Mr. Smith is one who is going to face up to the responsibility of these court proceedings, or is he one that is going to leave the state, or as is allegedly
If I
he
could
did.
just interrupt
So-
quickly for Your Honor.
One moment, counsel,
I'm sorry.
just briefly. So that's what this court must weigh as it relates to all the factors. Obviously, yes, we're still in the pandemic. These are serious allegations, and I'm not sure, Detective, if you can, I know there was some injuries. Was any of these injuries fatal? Do you know?
No, Your Honor, they were not fatal. There was 3 people that were involved. That was the vehicle that was struck. 2 out of the 3 people are in critical condition. I've been in contact with the families. They are making some progress, but it's still too early to tell in regards to everything.
Your
Thanks,
Honor, just in
Detective.
regards to,
Counsel.
thank you, in regards to the police showing up to Mr. Smith's home and taking him into custody, I would like the court to note, the officer did not state that Mr. Smith attempted to run or flee or evade the police when they did show up to his home. And we would state that a house arrest and a tether would be sufficient for this young, very immature man to deal with these allegations.
Thank you, counsel. Court is going to start with,
Say it again.
it was not a
I know.
part of the
and that's-
charges or any tickets, but it was mentioned by counsel. Mr. Smith, you're not to drive without a valid license. Do you understand that, sir?
Yes, Your Honor.
As
Yes,
it
Your Honor.
relates to Mr. Smith, I thank you. I did hear him. As it relates to Mr. Smith and his ability to pay, being age 18, and also being concerned about the general safety of the community, this court is going to lean towards the GPS tether house arrest. GPS tether with house arrest. Mr. Smith is not to leave that home during these proceedings. He is not to leave his home during these proceedings. He must be outfitted for his GPS tether before he leaves.
I don't know where we left.
Court is going to enter a personal bond on this particular matter, given his age and ability to pay, his lack of ability to pay. But the GPS tether and the house arrest should be able to make sure that he shows up for his court dates and that this court is able to monitor his whereabouts at all times upon being outfitted with that GPS tether. Next court date is a probable cause conference on March 7th at 8:30, March 7th at 8:30, preliminary exam, March 14th at 8:45. That's in front of Judge Jefferson. Personal bond, $25,000. Personal bond, $25,000.
Thank you so much, Your Honor.
We're all set. Thank you,
Mr. Smith, be sure to
Thank you,
come back to
Detective
court.
Brown.
Yes, ma'am.
Come on, you already Smith. You good?
Thank you, Your Honor.
We're all set. Thank you,
Good
sir.
seeing you, officer.
Yes, yes, great to see you.
Oh, yeah. Oh, he just gave me two.
Do you have anybody else ready?
We can move to page 2, if you have page 2.
Rinse. There you go. Take it. We didn't have a two. That's everything. Rinse it. Yeah. Take it. You can have. Forget it.
Rinsing. Like rinsing? Yeah. Rinsing. Rinsing. Be on it.
Stand on the line, say your name. Are you doing the book? Hey, are you doing what? What are you doing?
Good afternoon, sir. State your name.
Michael Rimson.
Michael Renson, okay. I have 2 matters for Renson. It looks like,
Yes.
all right. I'm gonna call both cases at the same time, counsel, if that's okay.
Thank you.
Calling case number 210-59801. People of the state of Michigan versus Michael Kevin Renson, AKA Michael Kevin Renson, AKA Michael Williams, and also calling case number 220-56002. People of the state of Michigan versus Michael Kevin Renson. Renson spelled R-I-N-S-O-N. Counsel.
Delisha Taylor Coleman on behalf of Mr. Renson. He stands mute, waives the formal reading, asking the court to enter a not guilty plea and recall any caseous warrants outstanding in these matters.
Not guilty plea will be entered on your client's behalf. Formal reading is waived and the recalling of all warrants. Warrants are set aside.
understanding that the court cannot do anything in regards to the habeas warrant and the bounds that have been previously placed, except for Judge Bryant. We would just ask the court to make Judge Bryant's case his personal bond.
Okay, I do not have is there another matter? Because I only have Judge Williams on this Michael Renson. I don't have a
Oh,
Judge Bryant.
Mr. Renson has 4 cases that we have before the court. The court would like me to read off their case numbers.
Please,
2
but
are
I do not have,
misdemeanors and
I don't
2
have those
are
other
felonies.
files.
Oh,
I don't have those files. So you have one for Judge Bryant. Give me that case number.
I have 2 for Judge Bryant.
Okay, give me the 2 for Judge Bryant. Read them both off.
I believe it's 21-04-5392-01
Wait,
and
92. Go ahead, counsel.
and 21-0573-0401.
4.
57304.
21057304. Okay, and both of those are Judge
Misdemeanors.
Bryant.
Yes.
Okay, misdemeanors. Okay, all right. So we're also going to include those case numbers, both in terms of Judge Bryant. I do not have, so is it capious information? I do not have those files. So are you saying those are capious history on both of those?
Yes, Your Honor. For the first case, capious 2422. And the other one case, capious November 29th, 21, which is interesting.
Yeah, capious amounts.
510%. I have a hard time understanding how the case number 4 is November 29th, 21, but capious number 2 is February 4th. For him to be capious on February 4th, he had to come after November 29th. So at any rate, we're asking for those to be personal bonds. And,
Attorney Coleman,
yes, sir.
my clerk is asking for the last case number. If you could repeat that again.
21-05-73-04-01.
That's a steam house.
That case number is coming up with a different defendant.
Oh, interesting. Okay,
All right, so
Never
let's
mind
scratch that one. So we only got the 3 matters.
thank you.
All right, thank you. As it relates to, let's see where we are. So not guilty plea will be entered in class behalf. We'll waive formal reading. As to bond, I think he was going into let's deal with the misdemeanor and I'll take care of that and then we'll go into the felony. As to the bond on the misdemeanor.
It was just from February 4th, 22. Mr. Renson was having issues in regards to
Who's gotta go back? It's not on the docket.
getting Zoom and all of that. So we're just asking for a personal bond for the misdemeanor.
As it relates to the personal bond, I believe you said this is a Judge Bryant case.
Yes, sir.
Not having all the particular facts and allegations in front of me, but knowing that those cases usually deal with assault of nature. So.
Oh, no, it's a retail fraud, Your Honor. I'm sorry.
Oh,
It's a retail fraud.
okay, thank you. All right. Because we waived formal reading, but as the court noted, I did not have a file. This is a retail fraud that helps it even more. So as it relates to this misdemeanor, the court is going to enter a personal bond on the misdemeanor, a $1,000 personal bond. No money's needed to be released today on the personal bond. The court does not have the file, so I cannot give you court dates just yet for that Judge Bryant case. As I get that date, I will give it to the DDC and as well as counsel.
Is somebody gonna be able to interview
That date, March 8th for Judge Bryant, March 8th for Judge Bryant. Pretrial date, March
you.
8th on the misdemeanor.
Thank you.
Madam Clerk works fast. Let's go back to the felony matters. I call both felony matters. We are ready to move forward as to bond on the both felony matters.
My understanding is that those bonds are 100,000 cash, and there is no information that this court would be allowed to change anything about them.
All right, thank you very much. Given that the council's representation that on both matters is 100,000, is that correct?
I only have for number 3, Your Honor, well, case 21-059-80101. I do not know the bond on the other matter.
All right, thank you. And thank you for helping the court, because I do not have the same information that you have. But given that these are very serious charges, assaultive on their face, given also the prior past capious history, Mr. Renson, and the prior criminal history. I do have a prior criminal history dating back to an 88 case, breaking and entering out of the Third Circuit. Some might consider that can be argued assaultive in nature. 89 for the same type of offense, breaking and entering out of the Third Circuit. Second degree murder, felony conviction, 95. And a felony firearm, 1995 out of the Third Circuit. So in general, assaultive in nature cases in the past, that's on the one file. Nothing different or new on the second file. But that file as well is assaultive on its face. This court has concerns about the general safety of the community. Looks like these were.
Your Honor.
Mr. Renson, you don't get to speak at this time.
Situations where these are retail establishments, I do believe. Looks like the same one for both matters, felony convictions. I mean, not felony convictions, felony charges. This court has some concerns, obviously, about their general safety with the repetitive nature of this particular charge. $100,000 cash surety is already in place on the one. $100,000 cash surety, that will continue. This court does not have any discretion to modify that cash surety bond. So it's $100,000 cash surety. As it relates to the other matter, not knowing if there is a cash surety bond on that one. If it is, then that would continue, but the court does not have that information. So the court is going to enter a.
Your Honor, I'm sorry, there is a 22056002 case that I don't believe has ever been addressed by the court. Is that correct?
That's the one we're addressing now.
Oh, okay. We would just ask
so
that the bond be the same bond as the other case, as the court has stated the jurisdiction in regards to that bond.
Sure, $100,000 cash surety.
Yes, sir.
$100,000 cash surety on the second matter as well. Mr. Renson, you can always address bond at future court dates. The next court date is a probable cause conference, March 7th at 8:30, March 7th at 8:30, March 14th at 8:45, March 14th at 8:45. That's in front of Judge Williams. $100,000 cash surety on both matters. Also, let me make it clear, no weapons of any kind. You cannot possess or use any weapons of any kind as well.
Man,
If there's nothing further, counsel, I would advise your client not to say anything at this time.
Mr. Renson. The court
just trying
cannot
to get
address
the
your
date.
bond. You will deal with the facts of these cases at your court date with the attorneys that will represent you. Everything you say will be used against you. So I would highly advise you.
What date? What date?
He wants to know a court date.
A court date, but that's all I'm asking.
And I'm sorry, I didn't hear you, but the people at the mound has the court date 3/7 and 3/14.
Yeah.
March 7th and March 14th. Thank you, sir.
Make sure. Yeah, and Hudson timed out. Make sure.
You're all set, sir. March 7th and March 14th. Next court dates.
Season 6.
Jonathan Young. Jonathan Young.
Fuller Young, come on, man.
Yes. Jonathan, Victor Carzell, Young.
Thank you, Jonathan Carzell Young. All right, call it case number 20057-304. People of the state of Michigan versus Jonathan Carzell Young. Counsel.
Felicia Coleman, P56278, on behalf of Mr. Young. He stands mute. Waives the formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
As to bond, Your Honor, we are requesting a personal bond for this 2020 case. Mr. Young has no prior convictions. He is 32 years of age. Black man with no prior convictions at 32. He's a high school graduate. He works for Priority Waste for the last 2 years, lives with his mom, and has 3 children, and he is the sole provider of that household. If he had been aware of this 2-year-old case, he would have surrendered himself. Cooperate with the detectives. And we are asking for a personal bond for this 2-year-old case. There's no other allegations that he has any contact with Jasmine Purdue and would not have any contact with Jasmine Purdue. My understanding, I only have home invasion as the allegation, Your Honor. But he would not have any further contact with that individual. And we have nothing that states that he has any capious history, as he has no prior convictions and would reappear at all future court dates. So we are requesting a personal bond. If the court feels something more needs to be done, then we would ask for a GPS tether, but allow Mr. Young to go to work because he is the sole provider of his household, of his mother, taking care of her. She's unable to work.
Thank you, counsel. The court has heard the representation of counsel as to the community, family, employment ties of one Mr. Young. The court will note that the underlying charge can be argued where there's assault. The court will further note it does not have a prior capious history for Mr. Young. No indication he's a flight risk. Court does not have a prior criminal history for Mr. Young. No indication that he is a general danger to the community. Court is going to implement a no contact order for Jasmine Alexis Purdue. Sir, you're to have no contact with Jasmine Purdue. Do you understand?
Yes, sir.
No contact means exactly that. Nothing face to face, nothing verbally, nothing in writing, nothing through social media, nothing through a third party. Do you understand that, sir?
Yes, sir, I do.
All right, thank you. Also, given that we're still in a pandemic and that this is a almost 2-year-old case and Mr. Young has not picked up any other offenses or charges, this court is going to enter a personal bond, $5,000, personal bond, $5,000. No monies need to be released today on this matter. Next court date, probable cause conference, March 7th at 8:30. Preliminary exam, March 14th at 8:45. Again, March 7th and March 14th. That's in front of Judge Jones. Anything further, counsel?
Nothing further. Thank you, Your Honor.
You're all set. Thank you.
I'm set.
Thank you, guys.
Yes, sir.
I'm gonna take you back.
Hard will.
APA Glenn and Officer McIntyre. I still
Yes,
don't have
Judge.
an
Yes, sir, I'm here.
Okay. One second. I still don't have, 1 second, DDC. I don't have any information still as it relates to Hardy. And I know you all have been waiting on some of the morning and a great part of the afternoon. The only thing I could suggest is possibly if you want to leave maybe your numbers, we'll try to reach you. But juvenile and that other matter that you're here on has not called the court. So I'm not sure what's going on over there. And so you can still wait in the waiting room if you so choose, but if you want to leave a number, we'll reach you once we're ready to call that case. How do you want to proceed, APA Glenn?
Judge, I can certainly leave my number. I know that we've been speaking with the Wayne County Jail. I mean, they have him. He's ready to appear. So I'm not exactly sure. We hear something about Monday or Tuesday, but legally he has to be arraigned today because he's a juvenile. So I'm not exactly sure. I know it's not on your end. It's just kind of a cluster of what's going on.
Sure, and I'm ready to go. So, but I was waiting for the contact person over there at Wayne County, and we never received a phone call from Wayne County as it relates to Mr. Hardy. So again, I don't know if you can find out, APA Glenn. I'll go ahead and place you all back in the waiting room, Officer McIntyre, and if we can get him arraigned, I'm ready to arraign him. But
Judge,
I just need to know how we're going to proceed. They need to call us to Zoom or the Polycom. I can get them arraigned.
What phone number can they call you first just to make sure that it's good to go?
The number here is 313-967.
No, they ain't talking. This is a whole nother case, bro. Somebody else.
2111. 2111.
2111. I will call over to the jail right now, Judge, and see what we can do.
All right, thank you.
Thank you, Judge.
All right.
Your Honor, I can remain. Yes, sir. I can remain in the waiting room.
All right, thank you.
Yes, sir.
And just in regards to Mr. Hardy, Your Honor, my understanding is from Judge McConicle, no officers will be able to
Attorney
testify.
Coleman. 1 second, Attorney Coleman. 1 second, Attorney Coleman.
Y'all did. Okay, so she just. Okay, with the number because
It's a misdemeanor.
she's gonna send.
Okay. All right. State your name, sir, that I have in front of me at DDC. State your name.
Quayshawn Lindell Harwell.
Hardwell. Okay, thank you. Let me call the case, counsel, and then we can go from there. Calling case number 20061573, people of the state of Michigan versus Quayshawn Hardwell. Counsel.
Delisha Taylor Coleman, P56278, on behalf of Mr. Hardwell, he stands mute, waives a full read, asking the court to enter a not guilty plea on his behalf and recall any and all previous warrants.
All right, thank you. Not guilty plea will be entered on your client's behalf. If there are any warrants, those warrants are recalled. That's the bond.
That's the bond. Mr. Hardwell has no priors. He just started at Family Dollar. He is a high school graduate, resides with his mother. In regards to him not appearing back in November of 21, he capious when his grandmother caught COVID and he's quarantined in the house, did not have a phone, and essentially had no place to go at that point. His grandmother did subsequently pass away. He is now working, residing with his mother. And if there's any way for the court to be able to have a bond reduction, we would ask for the bond for the CCW charge and non-assaultive to be reduced. We haven't been able to reach anybody from Judge Williams' court.
Thank you, counsel. What is the capious bond?
1,000 cash. He's just starting a new job, Family Dollar, so he has no money.
All right, thank you. Court has the representation of counsel as to the community, family, employment ties of one Mr. Harwell. Court would note that the underlying charge is not assaultive on his face. Court further notes it does not have a prior criminal history for Mr. Harwell. There's no indication he is a general danger to the community. There is a capious bond, given that Mr. Harwell missed the earlier court date. $1,000. You said cash surety, $1,000 cash surety.
1,000 cash surety.
Okay, $1,000 cash surety. This court does not have the jurisdiction to make that change or modify that particular bond. If counsel is able to get in touch with the judge on this particular case and new information is given, this court is surely open to modifying, but at this time, $1,000 cash surety must be continued. Next court date is a March 8th probable cause conference at 8:30, March 8th at 8:30, March 15th at 8:45, March 15th at 8:45. That's courtroom 440. That's a blind draw on the judge. Anything further, counsel?
Nothing further, thank you.
You're all set, sir. Have a good day.
I go right here.
Yes, sir.
State your name, sir.
Dejan Wise, sir.
Dejan Wise, thank you. Calling case number 220-56014, people of the state of Michigan versus Dejan Wise, counsel.
Delisha Coleman, P562778, on behalf of Mr. Wise, he stands to waive the formal reading. Asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. That's the bond.
As the bond, we are requesting a personal bond for this non-assaultive charge. And that Mr. Wise would reappear. We understand he did have a prior matter in 2018, but he is not on probation or parole. He does landscaping and snow removal, so it is a sporadic employment. He is seeking more stable employment. But we are asking for a personal bond. Mr. Wise be advised that he cannot have any illegal controlled substance in his possession or use. And he would reappear at all future court dates.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties of one Mr. Wise. Court would note that the underlying charge is non-assaultive on the case. Court does not have a prior capious history in front of it. There's no indication he is a flight risk. The court does have a prior criminal history dating back to 2013. Looks like felony conviction out of the Third Circuit, larceny in the building. A number of those, an unarmed robbery, 2013. Looks like a companion case out of the Third Circuit, out of the 16th Circuit, excuse me. The first one's out of the Third Circuit. The two had a December 2013 larceny and robbery out of Macomb County, 16th Circuit. In addition, a retail fraud out of the 16th Circuit, 2017, and a 2019 retail fraud, first degree out of the Third Circuit. Most of those, majority are non-assaultive on their face. Sometime has elapsed, not a lot of time, but sometime has elapsed from that last felony conviction, 2019, and today's charge that Mr. Wise is now facing. Still in a pandemic, sir, you're not to possess, use, purchase any illegal substances or narcotics. Do you understand?
Yes, sir.
Given that the matter before us is non-assaultive, and the majority of the prior felony convictions are non-assaultive as well, this court is going to enter a $5,000 personal bond, $5,000 personal bond. No monies need to be released today on this particular charge. Next court date is the probable cause conference, March 7th at 8:30. Preliminary exam, March 14th at 8:45. March 14th at 8:45. Again, March 7th and March 14th. That's in front of Judge Jones. Nothing further, counsel. You're all set, sir. Yes, Judge Jones.
Got it. Thank you.
APA Glenn, did you have an update for me?
Yes, Judge. I spoke with Lieutenant Reinhardt over at the Wayne County Sheriff's Office. He is calling over to the juvenile detention facility, and I gave him the court's number, the 967 number. and as well as the Zoom ID number, and they should be zooming in. So you may want to check whoever's in the waiting room for the Zoom account, and they're going to try to get them on, if not on now, within the next couple of minutes.
Okay, thank you. I'll keep reviewing the waiting room. I do have that capacity and ability. I don't see anyone new just yet for the case that we're speaking of.
Thank you, Judge.
I'll let you know, though. I'll bring you forward when I do. I'll bring all
Thank
the
you, sir.
parties. Thank you for the update. Okay, at DDC, state your name, please.
Julius Grant Dubard.
Julius Grant Dubard. Okay, thank you. Calling case number 20062-643. People of the state of Michigan versus, is it Julius or Julius, sir?
Julius.
Julius Grant Dubard. Counsel. Julius, thank you.
Julius with a U.
Thank you.
Julius,
No J,
yes,
just
thank you.
U.
Counsel.
Delisha Taylor Coleman, P56278, on behalf of Mr. Dubard, and he stands mute ways for reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Esteban.
Esteban, we are requesting a personal bond. These are non-assaultive charges on their face. Mr. Newberg, we do not have any case history for him, that he is not on probation or parole at this time. He does have a gunshot wound just recently. He is employed as a rooster tail dishwasher. He does have prior history, but has been out since 2015 and would reappear at all future court dates, living with his mother, brother, and son.
Thank you, counsel. The court heard the representation of counsel as to the community, family, employment ties of one Mr. Dubard. The court would note that the underlying charge is non-assaultive on their face. Court further notes it does not have a prior case history nor criminal history for Mr. Dubard. No indication he's a flight risk or a general danger to the community. We're still in the pandemic. Given no prior criminal history, the court is inclined to give your client a chance. Sir, court's going to enter a $5,000 personal bond. No money is needed to be released today on these charges. Next court date, probable cause conference, March 7th at 8:30, March 7th at 8:30, preliminary exam, March 14th at 8:45, March 14th at 8:45 in front of Judge Archer. If there's nothing further, thank you. You're all set, sir.
Thank you, Your Honor.
Well, if you're all set, my first one.
Come on, we'll take you back. State your name, sir.
Jaheem O'Neal.
Jaheem O'Neal, thank you. Calling case number 20062-643. People of the state of Michigan versus Jaheem O'Neal. Counsel.
Delisha Taylor Coleman, P56278, on behalf of Mr. O'Neal, he stands mute ways of formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Esteban.
Esteban, Mr. O'Neal Mr. O'Neal is asking for a personal bond. He's 20 years of age, no prior convictions at all. He works at Wendy's for the last 2 weeks. 12th grade, he has completed. He does have asthma, lives with his girlfriend and her mom. He has 2 children, would reappear at all future court dates. These being non-assaultive charges in a pandemic, we are asking for a personal bond.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties of one Mr. O'Neal. The court would note that the underlying charges are non-assaultive on their face. Court further notes it does not have a prior case history nor criminal history for Mr. O'Neal. No indication that he is a flight risk or a general danger to the community. Given his age, we're still in the pandemic, and that there's no prior criminal history. This court is inclined to give him a chance. Sir. Court's going to enter $5,000 personal bond, $5,000 personal bond. No money is needed to be released today on these charges. Next court date is probable cause conference, March 7th at 8:30, March 7th at 8:30. Preliminary exam, March 14th at 8:45, March 14th at 8:45. Judge Archer. That's in front of Judge Archer. Anything further, counsel?
Nothing further. Thank you, Your Honor.
You're all set, Mr. O'Neal. DDC, I know you're probably bringing out the third person. If you can also bring out a Tyrone Dudley after Mr. Stiff, Tyrone Dudley after Stiff, or fairly quickly, you have retained counsel.
Like when, so I can know like on my, they just gave me a perfect bond, so I can know like when they get the court date, my next court date.
You'll get all that when you get. I just trying to read it right. Step one. So I want to say it.
Martez James Stiff. Martez James Stiff, thank you. Calling case number 2006263. People of the state of Michigan versus Martez James Smith, counsel.
Delisha Taylor Coleman, P562278 on behalf of Mr. Smith. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived. As to bond.
As to bond, we are requesting a personal bond for Mr. Smith, defendant number 3. No prior convictions, not on probation or parole. Lifelong resident of Detroit, residing with his grandmother and sisters. He is seeking employment, but is a high school graduate from Henry Ford High School. Would reappear at all future court dates. We have no capious history, this being in a pandemic, and these charges being non-assaultive. We're requesting a personal bond.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties of one Mr. Stiff. Court would note that the underlying charges are non-assaultive on their face. Court further notes it does not have a prior capious history nor criminal history for Mr. Stiff. There's no indication he's a flight risk or a general danger to the community. Given his age, that there is no prior criminal history, no capious history, still in the pandemic. Of course, we're trying to give your client a chance. Mr. Stiff is going to enter a $5,000 personal bond, $5,000 personal bond. No money needs to be released today on these charges. Next court date, probable cause conference, March 7th at 8:30, March 7th at 8:30, March 14th at 8:45, March 14th at 8:45. That's in front of Judge Archer. If there's nothing further, counsel, you're all set, sir. Mr. Stiff, have a good day.
Thank you.
Thank you.
I'm good.
Yeah.
You said a retained case, Your Honor?
I do. I have a retained attorney docs for Mr. Dudley. So as soon as DDC gets the opportunity, they're going to bring his client up. Good afternoon, counsel.
Good afternoon, Your Honor. Good afternoon.
Do you have a P number?
P number 79657, Your Honor.
79657. Thank you.
Yep.
State your name, sir.
Tyrone Dudley.
Tyrone Dudley. Your appearance, let me get the case number. Calling case number 220-56004. People of the state of Michigan versus Tyrone Anthony Dudley. Counsel, your appearance.
Good afternoon, Your Honor. Honorable staff, Attorney Quentin Docs, P number 79657, on behalf of my client, Mr. Tyrone Dudley, who appears via Zoom, Your Honor.
Thank you. The not guilty plea will be entered in your client's behalf. Formal reading is waived. As to his bond.
Thank you, Your Honor. Your Honor, this is a second reissue by the people, Your Honor. I would like to remind you that my client had appeared at every court date on the prior case, Your Honor. We were at preliminary exam just Thursday, and the case was dismissed without prejudice, and the people reminded me on email Friday that they had put another warrant out for a reissue. I advised my client to turn himself in, and we were making preparations to do that, Your Honor. So it's not a flight risk. My client lives in the city of Detroit, has ties, lives with his sister, Your Honor. We're asking for a personal bond, Your Honor, you know, so we can diligently fight this case, Your Honor.
No. Thank you, counsel. Of course, heard the representation of counsel as to the community, family, employment ties, and the past court proceedings as it relates to Mr. Dudley. The court will note that the underlying charge is serious, but the court does not have any information that he is a flight risk or a general danger to the community. Given that there is a prior case proceedings or series of proceedings and court appearances, he has retained counsel. He did appear at all prior court proceedings. This court has no indication that he's a flight risk. Given that this court is going to enter a $5,000 personal bond, no money is needed to be released today on these particular charges. The court will also note, though, for the record, that there's to be no driving without a valid license. Do you understand that, Mr. Dudley?
Yes, sir.
You just went.
All right, thank you. Probable cause conference, March 7th at 8:30, March 7th at 8:30. Preliminary exam, March 14th at 8:45. That's in front of Judge King. Counsel, as you're aware, if there's any changes you need to make, you can make them with the courtroom directly. Again, Judge King.
All right, Your Honor, thank you, and it's good to see you again,
Thank you.
too.
Have a good day.
All right, now.
Likewise.
You said the 7th and the 14th?
Okay,
March
thank you.
7th and March 14th, yes, for Mr. Dudley.
That one case you already did, right? He had two retail parties.
Renton?
Yes, so you did one.
Yes.
That was 5 down.
Okay.
I put in both of them. That's the last.
All right. State your name, sir.
Iman McKinney Smith.
Iman McKinney Smith. All right, thank you. Calling case number 2256024. People of the state of Michigan versus Iman McKinney Smith. Counsel. Attorney Coleman, you're muted.
All that good language I just did. Delisha Taylor Coleman, P56278, on behalf of Mr. McKinney Smith. He stands mute, waives the formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond.
As to bond, we are requesting a personal bond for Mr. McKinney Smith. This matter is non-assaultive on its face. He has no priors. He's 20 years of age, is employed with DoorDash, and is a high school graduate with some trade school, residing with his mother as a lifelong resident. We have no case history, and that Mr. McKinney Smith would return for all future court dates, requesting a personal bond.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties of one Mr. McKinney Smith. The court would know that the underlying charge is non-assaultive on his face. Court further notes it does not have a prior capious history nor criminal history for Mr. Smith. There's no indication that he is a flight risk or a general danger to the community. Court's inclined to give your client a chance, given those factors. In addition, sir, you are not to use, possess, purchase any firearm or weapons. Do you understand that, sir?
Yes, sir.
Of course, going to enter a personal bond, $3,000. Personal bond, $3,000. No monies need to be released today on this charge. Next court date is probable cause conference, March 8th at 8:30. March 8th at 8:30. Preliminary exam, March 15th at 8:45. March 15th at 8:45. That's courtroom 440. That's a blind blind draw, excuse me. Judge by blind draw. Also, so you're all set, sir. DDC, Michael Rimson, who we've done previously, had one more matter. There was a fourth case. We have that. We can bring him back into the rotation. Michael Rimson.
Wait, excuse me. I just have to call people and say 3,000.
No, you got a personal bond. You'll be leaving in a couple hours.
All right.
Right.
Nope, stand online.
Good afternoon, sir. State your name.
Michael Brighton, good afternoon.
Good afternoon. Calling case number 2256022. People of the state of Michigan versus Michael Brighton. Counsel.
Delisha Taylor Coleman, P56, on behalf of Mr. Rinson. We're doing Mr. Rinson.
Michael Brighton.
Brighton. Well, on behalf of Mr. Brighton, he stands mute, waive the formal reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
As to bond, Your Honor, we are requesting a personal bond. Mr. Brighton is charged with non-assaultive crimes. While he does have a history from 2018, we would state to the court that it is two of them are out of the similar transaction and occurrence. He does reside with his girlfriend, a lifelong resident of Michigan, and is working at Second Chance Construction. He does have a high school, he would reappear at all future court dates, understanding he does have a history, but we are saying to the court this is a non-assaultive charge.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties, and one Mr. Brighton. Court would know that the underlying charge is non-assaultive. Charges are non-assaultive on the face. Court further notes it does not have a prior case history, no criminal history for Mr. Brighton. No indication he's a flight risk or general danger to the community. Sir, you're not to possess, purchase, use any firearm or weapons. Do you understand?
Yes, sir.
Court is going to enter a $5,000 personal bond, $5,000 personal bond. No money needs to be released today on these particular charges. Next court date, probable cause conference, March 7th at 8:30, March 7th at 8:30, preliminary exam, March 14th at 8:45, March 14th at 8:45. That's in front of Judge Williams. There's nothing further, counsel. You're all set, sir. Have a good day.
Thank you.
Yes, sir.
Okay, DDC and also counsel. I think I can take care of the Malcolm Hardy matter. Looks like juvenile is trying to get connect via the wait list. So the waiting
They
room,
are ready to be put into a wait room with him, Your Honor.
Okay,
My
breakout room.
law partners are ready.
All right, fantastic. So I'm gonna bring them forward. Sir, state your name.
Elijah Cole.
What'd he say, Your Honor?
One more time, sir.
Elijah Cole.
Elijah Cole.
They're
Elijah
ready
Cole.
for
All right, thank you. Calling case number 2256021. People of the state of Michigan versus Elijah Cole. Counsel.
Delisha Taylor Coleman, P56278, on behalf of Mr. Cole. He stands mute, waives the formal reading, asking the court to enter a not guilty plea on his behalf.
Not guilty plea will be entered in your client's behalf. Formal reading is waived as to bond.
As to bond, we are requesting a personal bond. This is a non-assaultive charge. Mr. Cole is 20 years of age, working at Walmart, high school graduate, has no prior convictions, reside with his parents and siblings, and would reappear at all future court dates. We have no statement of capious history.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties of one Mr. Cole. The court would note that the underlying charge is non-assaultive on his face. The court further notes it does not have a prior capious history for Mr. Cole. There's no indication he's a flight risk or a prior criminal history for Mr. Cole. There's no indication that he's a general danger to the community. Given those factors, we're still in a pandemic. This court is inclined to give your client a chance. Sir, you're not to possess, use, purchase any firearm or weapons. Do you understand?
Yes, sir.
The court's going to enter personal bond $3,000. Personal bond $3,000. No money is needed to be released today on this charge. Next court date, probable cause conference, March 8th at 8:30. That's March 8th at 8:30. Preliminary exam, March 15th at 8:45. March 15th at 8:45. That's courtroom 440. Blind draw on the judge. Thank you. All right. You're all set, Mr. Cole. You're all set. DDC, we're going to pause one moment. JDF, are we ready?
Delisha, I'll go ahead and interview him.
Thank you.
Okay, I'm gonna place you in the breakout room. All right, so JDF, you're still muted, but is this Malcolm Hardy?
Yes.
Yes, it is.
All right, thank you. Mr. Hardy, you need to speak to your attorney. I'm gonna place you in the breakout room so you can speak to them confidentially. And then once you're done, we'll bring you back and we can get Mr. Hardy arraigned. Give me one moment as I open up the breakout room, and then DDC, we can continue.
Okay.
Gary Jones.
This Brandon.
Attorney Stevenson, you should be able to go back into breakout room 1.
She just left Brandon, Mr. Hardy. Is Brandon doing Mr. Hardy? Okay. Thank you. Yeah, you put me in the breakout room and I rejected it, Your Honor. If you could put them in the breakout room.
May have to close them off. Somehow DDC went in there too. I'm not sure how. Let me close everything. Okay, DDC, you're back. Okay, everybody's back. Let's try this again, everybody. I apologize. Let me open up a different one.
Your Honor, before we start, Mr. Hardy, we would ask the court to not be recording.
Mr. Hardy's going into breakout room at this time, so there will be no recording.
Thank you.
Thank you. One moment. Okay,
Your name,
I'm
sir?
gonna move you to breakout room 3, JDF. Breakout room 3. Let's go there. And then Attorney Stevenson, breakout room 3. Okay, everybody else, we should be good. All right, we're good on everybody else. Sir, state your name. This is Gary Jones.
Yes, sir.
All right, thank you. Gary Jones, counselor. Case number 2256027, people of the state of Michigan versus Gary Jones, counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Jones. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading his waive as to bond.
As to bond, Your Honor, we are requesting a personal bond. This is Mr. Jones. This is a non-assaultive crime. Mr. Jones is charged with being 23 years of age, no prior convictions. He is a caregiver with the state of Michigan and a high school graduate. He resides with his mom and a sibling and has one child. We have no cases history, no conviction history, and we are requesting a personal bond.
Thank you, counsel. Court heard the representation of counsel as to the community, family, employment ties of one Mr. Jones. Court will note that the underlying charge is non-assaultive on the space. Court further notes it does not have a prior capious history nor criminal history for Mr. Jones. There's no indication he's applying risk or general danger to the community. Sir, you are not to possess, use, purchase any firearm or weapons. Do you understand?
Yes, sir.
We're still in a pandemic. Court will weigh all those factors. Sir, the court's going to give you a chance, $3,000 personal bond, $3,000 personal bond. No money is needed to be released today on this particular matter. Next court date, March 8th at 8:30, March 8th at 8:30. That's your probable cause conference. March 15th at 8:45, March 15th at 8:45. That's your preliminary exam. Again, March 8th and March 15th. That's courtroom 440, blind draw on the judge. If there's nothing further, counsel, you're all set, sir.
Thank you.
Thank you. Have a good day.
Thurman. Yeah, okay.
Good afternoon, sir. State your name.
Good afternoon, Montel Thurman.
Montel Thurman. Montel D'Angelo Thurman. Thank you. Calling case number 220560026. People of the state of Michigan versus Montel D'Angelo Thurman. Counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Thurman. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading his waive as to bond.
As to bond, we're requesting a personal bond for this non-assaultive charge. Mr. Thurman, having no prior convictions, no assaultive history, is a lifelong resident of Michigan, residing with his wife and 3 children. He works at Instacart and has a high school diploma. We're asking for a personal bond.
Thank you, counsel. The court heard the representation of counsel as to the community, family, employment ties of one Mr. Thurman. Court would note that the underlying charge is non-assaultive on this case. Court further notes it does not have a prior capious history nor criminal history for Mr. Thurman. There's no indication he's a flight risk or general danger to the community. Sir, you're not to possess, purchase, use any firearm or weapons. Do you understand?
Yes.
We're still in the pandemic, Justice. court is inclined to give your client a chance. Given all those factors as previously mentioned, $3,000 personal bond, $3,000 personal bond. No monies need to be released today on this charge. Next court date is probable cause conference March 8th at 8:30. Probable cause conference March 8th at 8:30, and March 15th at 8:45. March 15th at 8:45. And that is courtroom 440. Again, blind draw on the judge. If there's nothing further, you're all set, sir.
Thank you.
Thank you.
Oldham.
Oh yeah, you pronounced it.
One second, that's in the page.
Nope, stand right there.
State your name, sir.
Antoine Darnell Fulgham.
Antoine Darnell Fulgham, thank you. Calling case number 220-44290. People of the state of Michigan versus Antoine Fulgham. Counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Fulgham. When he stands mute, waives a formal reading, asking clerk to enter a not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask the bond.
Bond, Your Honor, we are requesting a personal bond. We understand that this misdemeanor is an assault crime. He would not have any contact with the complaining witness in this matter. He does reside with his cousin, would not be at the location listed of the incident. He works at KBS Essentials and has a GED. He does have kidney disease and asthma, and with COVID, it is a serious concern. We are requesting a personal bond with no contact with the complaining witness, Your Honor.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties. The one, Mr. Fulgham, court would note that the underlying charge is serious on his face and assault. The court further notes it does not have a prior capious history nor criminal history to Mr. Fulgham. There's no indication he's a flight risk or a general danger to the community. However, this court does have some concerns with the general safety of the complaining witness in this matter, Kirsten Harris. Sir, you are to have no contact with Ms. Harris. This case is ongoing. Do you understand?
Yes, sir.
No contact means exactly that. Nothing face to face, nothing verbally, nothing through social media, not even through a third party. Do you understand that, sir?
Yes, sir.
Even if she reaches out to you, you are to have no communication or contact with her. You cannot respond. If you respond, sir, you may end up violating your bond and thus could be incarcerated. Do you understand that, sir?
Yes, sir.
Court is hoping that the no contact order is enough on this particular matter. Going to enter a $5,000 personal bond, $5,000 personal bond. No monies need to be released today on this particular matter. Next court date is March 8th, pretrial date at 8:30, March 8th, pretrial date at 8:30 in front of Judge Garrett. Judge Garrett, anything further, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. Have a good day.
Thank you.
In three. And lines in.
State your name, sir.
Ron, last name Willis.
Revon Willis, thank you. Calling case number 2256030. People of the state of Michigan versus Revon Willis, counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Willis. He stands mute. Waives a formal reading, asks the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask the bond.
As to bond, clerk can bear with me for just 1 second. I got a lot of new papers. Did he say Whitaker? What's his name?
No, this is Willis. This is Willis.
Willis. Mr.
Rayvon
Willis. Thank you, Your Honor. Mr. Willis, we are requesting a personal bond for Mr. Willis. On his face, these are non-assaultive charges. He has no prior convictions. We do not have any capious history. He works at Building Works Home Improvement, is a high school graduate, resides with his mom and sibling, and would not have any complaining witness, would not have any contact with the complaining witness, and would reappear at all future court dates, Your Honor.
Thank you. Court subject to representation of counsel as to the community, family, employment ties of one Mr. Withers. Court would note the underlying charge is non-assaultive on his face. Court further notes it does not have a prior case history nor criminal history from Mr. Withers. No indication he's a flight risk or a general danger to the community given his age, and that it appears to be his first offense that this court has in front of it, and that there's no prior criminal history nor case history. This court is inclined to give your client a chance. Personal bond $5,000. Personal bond $5,000. No money needs to be released today on this charge. Next court date, probable cause conference, March 7th at 8:30. March 7th at 8:30. Preliminary exam, March 14th at 8:45. March 14th at 8:45. That's in front of Judge Williams. Anything further, counsel?
Nothing further. Thank you, Your Honor.
You're all set, Mr. Withers. Have a good day. Thank you.
Where's you at? Where's? 1 second. Come on, Whit. Where you going? I got a meeting. Yeah, go ahead. You got a meeting, huh? Wait.
Hey, did you have that other guy?
Got one?
Stand right up. Stand on line saying.
Frank.
Yeah.
You get the first one?
Yeah.
Good afternoon, sir. State your name.
Good afternoon, sir. David Whitaker.
Thank you, David Whitaker. Calling case number 2256028, People of the State of Michigan versus David Whitaker, counsel.
Alicia Taylor Coleman, P56278, on behalf of Mr. Whitaker. He stands mute, waives a formal reading, asking the court to enter not guilty plea on his behalf.
Not guilty plea will be entered in client's behalf. Formal reading is waived as to bond.
As to bond, Your Honor, this is a one-count charge. He would not have any contact with the complaining witness. He is employed at D&D Investments in Quartet. Has a 10th grade education. He does reside with his aunt, lifelong resident of Michigan, and would reappear at all future court dates, Your Honor. No contact with the complainant.
Court subject to representation of counsel as to the community, family, employment ties of one Mr. Whitaker. Court would note that the underlying charge this court takes seriously. Some may argue with his assault on his face. Court would note it does not have a prior case history, no criminal history for Mr. Whitaker. There's no indication he is a flight risk or general danger to the community. Court does have some concern with the complaining witness and her safety at Tammy Davis. Sir, you are to have no contact with Tammy Davis. Do you understand?
Yes, sir.
No contact means exactly that. Nothing in person, nothing in writing, nothing through social media, not even through a third party. Do not show up at her place of residence or her place of employment. Do you understand, sir?
Yes, I do, sir.
Let me try to make it as clear as possible. Let's say you're at a public store or public park. You're thinking to yourself, you have every right to be at that public park or that retail store. If Miss Tammy Davis shows up to either location, you are the one that has to leave that location immediately. Do you understand? You must stop your shopping, leave the retail store, leave that public park. Do you understand?
Yes, sir. Yes, sir.
Even if Tammy Doss reaches out to you, you are not to respond. If you respond, sir, you may be found in violation of the bond conditions and you could be arrested. Do you understand, sir?
Yes, sir. Yes, sir.
Court's also going to implement a GPS tether. GPS tether in this particular matter, court will allow you to go from your place of employment to your residence only. Place of employment and residence only while this case is ongoing. Court's going to enter a $10,000 personal bond, $10,000 personal bond. No monies need to be released today on this particular matter. You will need to be outfitted with his GPS tether. Next court date is the probable cause conference, March 7th at 8:30, March 7th at 8:30. Preliminary exam, March 14th at 8:45, March 14th at 8:45. That's in front of Judge Jones. Anything further, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. Have a good day, Mr. Whitaker.
Okay, you too, sir.
Come on, Whitaker. Come on, Whitaker. If we can bring Michael Renson back.
Yeah, the personal mom, they gotta go to your tether, and they not, it doesn't, I don't know. at your. Yeah. Yeah, so, for the juice, you gotta get a tether and then they're gonna cut you loose. But then yesterday you had, this is what I'm lost on. You had a pro hold. Well, no, because it was issued yesterday, and then yesterday.
Did we do Tyrone Dudley, Your Honor?
That was retained counsel,
Okay, thank you.
That's it. Until your next court date.
I did, I wrote it on there for you.
Come on, Mr. Room. Stand on the line.
Okay, Mr. Renson, this is, we're calling you back for this particular case, case number 21055. I'm sorry, 210-44040. People of the state of Michigan versus Michael Kevin Renson, counsel.
Delisha Taylor Coleman, P56278, on behalf of Mr. Renson, he stands mute, waives a formal reading, asks the court to enter not guilty plea on his behalf.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
As to bond, Your Honor, we previously addressed Mr. Renson. I did inform the court of additional misdemeanor and felony matters. We are asking if this is the misdemeanor matter, which I don't know if it is.
It is the misdemeanor. It is the misdemeanor in front of Judge Bryant.
We are asking for the bond to be made into a personal bond. Mr. Renson has a significant bond in a felony matter, and we're just asking for a personal bond and recall the capious warrant.
Thank you, counsel. If there is any capious, we ask that warrant is recalled. Of course, there's the representation of counsel as to community, family, employment ties of one Mr. Renson. This is a case that we have already arraigned Mr. Renson on 3 other matters. This is the 4th matter, is a misdemeanor matter. In the other matters, which were felonies, there was a cash surety bond, which just court did not have any jurisdiction to change or modify. As it relates to this particular matter, is a misdemeanor. In this particular case, the court is going to enter a personal bond of $1,000, personal bond of $1,000 on this matter. Next court date is a pretrial date of March 8th in front of Judge Bryant, March 8th in front of Judge Bryant. If there's nothing further, counsel, you're all set, Mr. Renson. Thank you, DDC, for bringing him back. Looks like I have one Chantalise McFarland, one female. DDC, is that correct?
On Renson's bonds,
yes,
it was 2 $1,000 personal bonds and 2 $100,000 cash surety bonds.
That is correct.
Okay, I just want to make sure. And I'll see you on the female side in just a second.
See you on the female side. Okay, as it relates to Mr. Hardy, all the parties on Mr. Hardy. Let me stop.
And is this matter
YouTube.
being no longer, I'm sorry, Your Honor, is this matter being off of recording?
I'm getting ready to stop the recording for YouTube. Give me one moment.